Yes, hand over.
New stay application.
This is original site. What? Please remind us what is.
This is against there was a decision rendered by a division bench presided by Justice Surajit Banerjee and Justice Kaushik Chandra, where both judges arrived at a different conclusion with regards to refund of an EMD amount in a tender floated by the KMC. The matter was thereafter placed before the Chief Justice. Especially assigned the matter to the
Now pleadings are complete.
pleadings are complete because
Paper books have been filed.
yes. The appeal was the judgment was also delivered, but it's
Is differed with the other division.
no merits. Two judges in the same division bench differed with each other.
Very good. Then how it has to be? It has to be referred to a third judge.
Well, that was what we apprehended as well, but whereas we were informed as well that this will be referred to another division bench rather than being referred to a
How
larger
can
bench.
that-
Well, we'll kindly keep it as to be mentioned at least. I have a leader in the matter, then we'll place the relevant rules and at least try to satisfy your lordship.
Assignment before a division bench presided over এরকম লেখা আছে?
This is 40.
New matter.
New matter. New application.
Reapplication. Sir, आपने यहाँ पे
Must have copy
What is that?
when there was appeal like
Mandamus appeal. Our determination. Which year appeal?
2024.
What order you are showing us?
This is order, no? This is mentioned slip. The order was filed, passed by Justice Jaimallo Bhakti, Justice Gaurango Kanat. It is supposed to appear on 8/11/2024, section 90.
Connected with that matter of yours?
No, it is different matter. Two different matter, different appeal against the order of the single bench for passing some order beyond the scope of contempt petition.
So what did the division bench say?
Division bench fixed for hearing on 8/11/2024. For final hearing, affidavit was complete, everything was complete.
Paper books have been filed?
No direction was for paper book.
বলছে তো different.
No direction, there was no direction for paper book. No direction for paper book.
Different matter. Is it relating to the contempt which appeared?
To some extent. So that it should
So
come.
you give the slip, it will appear on the said date along with that. ওই একটা মেনশন করেছিলেন না উনি?
Was
Let us see, it will appear on that. Yes.
Below, this is for pay protection. For pay protection,
Are you mentioning an
yes,
application?
mentioning
Application.
application.
Which year?
2021.
So where is your notice to the other side? Please
I
give a
sub-
notice and mention. Yes,
My lord, this is group 2 matter, my lord. This matter filed on January 2025, but till date matter was not appear.
so why
My-
didn't you mention? You never mentioned. You filed it and slept.
My lord, this is urgent.
Did it appear on any occasion?
Last time it appeared on March, my lord.
Then you give a notice to your other side and mention.
May I be permitted to mention on habeas corpus application? Notice has been given to the other side. This was heard by the Honorable Vacation Bench, and after passing an order, subsequently it was fixed to be appear in the regular bench.
What
Notice-
order passed?
Kindly see.
ওটা নিজে- You haven't gone through it.
No, I have no submissions were recorded. Report was directed to be filed. Thereafter, Lordship, a report was directed to be filed by the respondent authorities.
Abduction of the life interest of the interest of the আমাদের রিলেশন যে
Lord, here is the
বুধবার দিয়ে দিয়েছো give a further notice it will appear on the habeas corpus date কি বলেছে
I'm grateful.
That's what we thought. That must be to the, because that's the.
Yes, that even I assume the same thing. Well, it's been the matter.
অরিজিৎ ছিল না your mind. If
I-
you find that some other interpretation appears, then you come and.
I'll place that, my lords. I sincerely apologize.
But
to
when I
just-
will sit singly, when I will take matters, I do not sit singly. Let us see. You also check it up. You also check it up, and when I sit singly, you mention before me with a
But
notice.
just to clarify, my lords, from what I understood from the notification, the matter has it been assigned to your lordship to hear it out singly, or has it your lordship will be sitting with two other judges?
That is usually when the assignments are made in that manner, the
Yes.
rider is to be placed before a division bench presided over by the
Yes,
CJI.
yes, exactly. But the composition of the other, yes, my lords. So it's only presided because only the presiding
Brother
judge.
is right, because it cannot be assigned to
A second division
any
bench.
single judge who is junior to Justice Sukhojit Banerjee.
Yes.
সেটার কোনো নিয়ম নেই। It was in 11th of April 2023.
That's the assignment. Was we?
When were you briefed?
Well, I was briefed recently. I was briefed because your lordships will recall before vacations I had mentioned the matter and your lordships had indicated that this is a year.
The reason for the urgency is you. 23.
This. I saw
You
this.
cannot hand over a copy of this.
No, I understand, Milaj. I understand.
You also, when I sit singly, you mention.
I'll mention again when your lordships. I'm grateful,
Yes.
Milaj. I'm grateful.
My lord, this matter, my lord, petitioner prayed for withdrawal of the case. My lord, when matter was, my lord, listed on that day, petitioner, my lord, argued that he has instruction to proceed with the matter. My lord, thereafter, my lord,
But how did it go before a single bench? 8th of March 2024 matter appeared before a single bench.
no, my lord, this matter was appearing before your lordship on, my lord, 9/9/2025. 1 week after vacation, there is a direction.
We have passed any order.
Yes,
We passed any order.
yes, 9/9.
Order pass করিনি
My lord, only, my lord, 1 week after vacation. গৌতম
সৌগত মিত্র
সৌগত মিত্র
9 তারিখে লিস্টেড হয়েছে 9 তারিখে লিস্টেড ছিল
on 9/9/2025, my lord, matter was listed. Out of turn, this was mentioned on the plea that matter would be, my lord, not pressed.
It will not be pressed.
Yes, but
Appeal will not be pressed.
yes, this was the contention. But when matter was called on, learned advocate wanted to proceed with the matter.
Where is he? Where is your other son?
দিনে সমানে টাইম নিয়েছে বলে আর হয়
Acha, Mr. Chodbade, come to the order impugn.
My lord, order impugn since 1992. My lord, my lord,
25th July order, kindly come to that.
yes, my lord, 25th July, my lord.
Come to the last line. Last line of the first page. Respondent number 3 has produced.
Yes, my lord.
Do you have this memo?
I have that, my lord. That is, my lord, instruction. I have that instruction, my lord.
But why will he not press? He has said that there was he retired in 2011.
My lord, 19, my lord, my lord, got the job on production of a MA certificate. Subsequently, it was found on verification from the university, it is fake.
Then did you
One-
terminate his service?
One criminal case was registered. The district inspector of school directed the school for termination. He was in custody, but since 1992 to 2011, he was absent from service. The district inspector of school directed the school authority for taking step for termination. That order was not challenged, my lord. That order, my lord, it appears from page 31 of the stay application that there is a direction. My lord, this is a deemed termination. 92 to 11, 19 years he was absent. He was custody and criminal case was pending.
So this memo was not challenged. 2019 memo, page
No,
31.
no, not challenge.
Instruct this school to proceed to terminate. But they have not terminated.
My lord,
Allegedly he was absent, but his service has not. But his service has admittedly not been terminated.
and my lord, he approached.
Let
My
us
lord,
understand.
yes, yes.
Allegedly he did not join. Then it can be construed to be deemed resignation.
Deemed termination. My
But
lord.
there has to be an order to that effect.
My lord,
Otherwise, the approval of his service by the DI, that still stands.
my lord, he moved a writ petition, page 140 to 142. Where was my lord, there was a direction for resumption of service with a condition that if the my lord, certificate my lord, appears to be false, then he has to my lord, return back all benefit. But in spite of that, he did not join. This is my lord, written instruction also. If your lordship kindly so desire, I can inform Mr. Mitro.
The particular date that he mentioned রেখে দাও।
No, just now I already I reached.
Dropped. Oh.
I reached it.
Then what? You don't want to proceed with the appeal?
No, my lord, my client is proceeding this matter since it has been preferred an appeal against the trial court's order.
But
So,
you
your lord,
said that you will not proceed. That is what.
Yes, yes.
no, on earlier occasions, my lord, it was my lord on telephone.
All right. Place
Then-
that you are not ready.
My lord, today, my lord, just now I have no time, my lord, to my lord, read this brief. My lord, your lordship, my lord, kindly take it any day, my lord. I will appear. If the appeal has been my lord, preferred, even the appellant has already been retired from his service without getting any
2011.
pensionary benefit.
Retired in 2011
2011.
after 19 years of
My lord,
absence.
retirement pursuant to the in 2006 writ petition was heard and judgment has been delivered by my lord Justice Bhattacharya, Jyotirmoy Bhattacharya. Then my lord, there is a direction that if the MA degree is false and fabricated, then the
There's a
case to be considered.
There's a finding by the single judge that it's a fake decree.
No,
Yes.
recently the single judge,
The
but it has not been. But it has not been well, only for on the conclusion that the petitioner has not yet been joined in the school since long time. But the school authority has been annoyed.
Then place
And-
the matter. If
Well,
you are
the-
ready, you place the
Just
matter.
now,
Mr. Chattopadhyay, you have that written instruction with you?
I have.
Either you say you are ready and willing to proceed, or you say when you will be, you have no instruction, total instruction you don't
No,
have.
no.
The next Monday,
next Monday.
come next Monday, order.
My instruction be kept with
Where
them.
is your,
I have
take
handed
it
over.
back. Okay, ওনাকে দিয়ে দাও instruction. আসুন, play school.
Next Monday.
Next Monday will be a monthly.
আরে করার জন্যই তো এলাম ছিল
So it will be on 4th. It will be on 4th.
Fourth.
Next Monday will be combined list. 4
Fourth.
তারিখে order দিও না, just 4 তারিখ।
দেখি 4 তারিখ
করে দাও বাবা। আমি এসে বসে থাকছি।
Item 2, I appear for the question. Your Lordship, Mrs. Koili Bhattacharya is appearing for the board. She has not come to court today, so I am praying for not this week.
I am appearing on behalf of the respondent number 1, 2 and 4. State court.
State ki.
He asked Ms. Bhattacharya to take instruction.
Yes, Your Lordship, she has not come to court today, so I am praying for not this week.
Next Tuesday রেখে yes,
হবে না order হয়নি তো।
My lord, in this matter, I am for the appellant. My lord, it's primary transfer matter below 5 years on a special ground. My lord, in a similar matter, your lordship has been pleased to fix on 4th November in similar matter, where your lordship was pleased to grant the leave to file supplementary affidavit enclosing the transfer has been made on a special ground that has been done by the authority. Now, my lord, it is required to bring your attention on a special paper where the authority has granted the transfer.
Did we hear it earlier?
No, my lord. My lord, in a similar matter, your lordship was pleased to fix on 4th November 2025. I want to fix this matter on 24th. And my lord, kindly allow me to file supplementary affidavit in this matter.
4th
24th. No, 4th of November.
4th November, did we fix similar matter?
No, one matter your lordship fixed on 4th, but I do not know whether this is the similar with that.
Similar matters.
That my lord.
Let it appear on 4th. Let him go through the brief.
My lord.
Further supplementary affidavit if required, we will consider thereafter.
My lord.
7 তারিখ।
Defect
Leave only that.
What defect? You have checked the defect. Correct the defect in the meantime.
My lord. Grateful to you, lords.
Not yet been completed, your lordship.
My lord, I am appearing one of the respondent number 4, the district library officer, my lord. The copy has not been served before the government pleader's office, my lord. Today I have came to know from the government pleader's copy was not served.
You don't have any copy now?
No. My lord, on behalf of government pleader office, I cannot receive. I am appearing on behalf. I had to serve the government pleader's office.
Tried to serve the copy, but in presentation form, it was mentioned that next date for admission was 14 August 2025, and CAN applications were filed on 13 August, so that they have not received the
Complete service. You complete service and come back. When can you come back?
lordship on next Tuesday.
10th.
Grateful, your lordship.
I am appearing on behalf of respondent number
You
4.
are not recording copy. He will complete service then. Not in this
For
manner.
respond-
You have to serve the GP's office. Thereafter, the brief will be allotted.
Lordship.
Yes.
Take it up and make this
Lordship.
service. Yes, পরেরটা yes.
আমাকে কপিটা দিন। এটা একটা অর্ডার করলে না কিন্তু জিপি অফিস নেবে না।
Lordship, in this matter, Mr. HON'BLE is leading me in this matter. Lordship has asked for his assistance on the last occasion.
We are leading you.
Mr. HON'BLE, Lordship has specifically asked for his assistance.
Affidavit was directed by your lordship. The affidavit came, kindly sees the previous order made by the coordinate bench, apropos which affidavit was filed in your lordship court. Your lordship was disinclined to accept the affidavit, and your lordship wanted him to come with a fresh affidavit, return that affidavit.
Yes, your lordship. He was just here. He has just left for court number 34. There's a
Good, but what is the
short passover, your lordship.
what is the instruction given?
Instruction, he had a, I am not privy to the instruction. He had a word with the department directly, your lordship. That's why, your lordship, his presence is very much required. For I have been told that to seek short passover from your lordship.
Passover, we don't know when we can. He has to wait then for the entire.
Madam,
Come tomorrow then. Tomorrow?
Tomorrow, your
That
lordship.
affidavit, you know that there was certain deficiencies.
I'm
in the
aware of that.
affidavit.
We,
It was affirmed by somebody else, no?
no, your lordship, no, nothing like that. Steps
yes,
were
yes,
not,
yes.
steps were not taken also, your lordship. There were certain steps was required to be taken.
Sent to whether he is inclined to any fresh affidavit or not. We do not know. Otherwise, we proceed on.
May I most humbly, if it commends to your lordship to pick it up at 2 p.m. today.
No, not today. Yes, not
Tomorrow.
today. Go to ask him to be here tomorrow.
Much obliged.
The next week.
And the appellant manner.
Item number 6.
Is presently a lecturer in Calcutta University in the field of ancient history and culture. He's a lecturer in ancient Indian history and culture in Calcutta University. I'm sorry.
My lord, I appear for the state respondents in this matter.
My lord, I am appearing for the University of Calcutta. My lord, I am led by Mr. Nilotpal Chatterjee. He is on his legs before courtroom number 1.
Let us hear now. Oh, delay condonation allowed.
My lord.
You have filed 2 stay applications.
And one stay application or can
Third application can 2 has been filed.
2 volumes, my lord, 2 volumes of the same application. Since it had exceeded 150 pages according to new norms, my lord.
Earlier, you did not file any stay application. Can 1 is a section file that we have allowed.
That has been allowed, but can 2 is a stay application, my lord.
Stay. Yes. Show us the order. Where is the order? Oh.
Impugn order is at page 27, my lord.
Post filled up.
Post has not been filled up, my lord.
Post has not been filled up.
I don't have the current information. It is not.
Simple question.
It is not, my lord. It is not. It is not filled up yet. Probably.
Advertisement of 2019, you have not yet filled up.
That professor in SC category for this Southeast. No suitable candidate is found, that's why.
I had applied.
Writ petition was heard on affidavits.
I don't. I don't.
So what interim order you are praying?
It has to be heard out, man. But
So it has to be heard out. You file your paper books.
Everything is on record. Subject. If my lord permits, not everything is part of the stay application. If my lord, of course, the regular style, regular method is to file the paper books. But if my lord dispenses of with the paper books, it can be heard, my lord. That is my only humble prayer. I leave it to my lords.
There is no scope for any interim order.
It has to be heard out. And only interim order if
Heard out means if the post is filled up in the meantime. It was a post of professor in schedule in SC category. Reserved for SC. Professor in the Department of South and Southeast Asian Studies.
My lord, I was the only candidate who had applied for the post. Even thereafter, I was not selected.
No, then ultimately, did the university take any decision to cancel the advertisement and proceed afresh?
I am not aware. I do not think they have done
You
it.
have to be aware, na. We are asking you whether they.
According to my instruction, they have not. According to my instruction, they have not. The
So
university.
then we will say that there is no scope for any interim order. We will dispense with the filing of paper books.
But if a short day, because if a new advertisement comes up thereafter.
Where is Mr. Chatterjee?
It is on his legs before courtroom number 1, my lord. My lord, as per this advertisement, interview was conducted, and it reached its finality as candidates were selected.
Place your case. What is the case? Let us see.
And I am in fact a lecturer in ancient history and culture. I teach in Calcutta University as a lecturer. I had applied for the post of professor of South and Southeast Asian Studies.
Presently, you are employed as a lecturer in Calcutta University. So then you wanted to go to the post of professor in a different department.
In a different department, both are not.
So in-service candidates were allowed participation. Very good. Then what happened?
I was the only candidate in the scheduled caste category, but I was not selected initially. So I came up with a writ petition. In fact, no results were disclosed. Nobody was recruited. I was not recruited. Nobody else was also recruited. I came up with a writ petition for disclosure of the results and for recruitment of mine. They came up with an affidavit in opposition stating for the very first time that my selection has been rejected, and they have given marks for something called demo experience, which was not even conducted.
Then where is the final order of rejection of your candidate?
There's no final order of rejection. Their affidavit says that I have been rejected since I do not comply with the 50% marks threshold, and they say that I have.
Show us the advertisement.
Right. 82, my lord, page 82. The relevant portion is at page 85, which concerns me.
Page 85, yes.
85, my lord, will clause 13, South and Southeast Asian Studies, my lord.
Page 85, clause 13.
13, my lord, at the very top, at the top, my lord. South and Southeast Asian Studies, my lord. My lord will see third from the top, Professor. 2, 1 is for the unreserved category, 1 for scheduled caste category. I had applied for this post. I belong to the scheduled caste category. There's only one post in the category and there's only one applicant as well. That is me.
Now, what is the procedure towards selection? Sir, you are not ready.
Kindly not take me on it, but
be ready on the matter.
Procedure.
We are helping you. We are asking you, do you want any interim order? 5th November. 5th November is a holiday. 11th November. You take all instruction in the meantime. Yes, next. Come ready with the matter with a short list of dates and whether you are seeking for any interim order. If you say that there is no scope of interim order, we will fix a date for final hearing upon assimilation of our reports. Yes, next. All adjournment. All vacation has not ended. All adjournment.
Bhubrubhan Bera is appearing in this matter, but he went to Bangalore for his mother's treatment. Advocate on record, Bhubrubhan Bera is appearing in this matter, but he went to Bangalore for his mother's treatment. That's why I'm praying for not this week. Kindly.
11th November. Yes, next.
And I appear for the respondent writ petitioner.
But this is an appeal by the state.
Well, I have only one sentence to say that this is a second round of litigations. In the first round of litigations, the state questioned that High Court doesn't have jurisdictions. It came up to your Lordship's division bench. The Lordships negated it. Now, this time, this is on merit. The writ petition has been allowed. And urgency in the matter is, whole matter is only for 1 year, starting from May 2025, and it will expire in 25-26. Now, I am the anesthesiologist. So starting from May itself, I am at home. I am not able to be in the operation room. So effectively, I will lose all my aptitude because it's a 1 year bond.
Yes, Mr. Ask your junior to effect the corrections. The corrections. Yes.
Number only Millard, a short recollection of facts, since your lordships were pleased to Millard consider this matter at the interim stage. But here, Millard,
maintainability issue.
On the maintainability issue, Millard, on the maintainability issue, Millard, my submission was that this is rendering public service.
So go to the tribunal.
Go to the tribunal. Millard, I did not succeed because your lordships were of the view that no, it does not amount to any public service. Here, Millard, now, Millard, the final judgment has come. Astonishingly, all the principles of public employment has been applied. All the principles of public employment. I'll take it as my last point. But primarily, Millard, the question, Millard, which has been framed by his lordship, Millard, your lordship will find, Millard, at paragraph 1. The doctors, other than the government-sponsored in-service doctors, after completing postgraduate and postdoctoral courses from the state medical teaching institutions as per indemnity bond executed by them at the time of admission are obliged to serve the state by working in different government hospitals as senior residents for a certain period of time. The Department of Health and Family Welfare, Government of West Bengal, in order to get such service of the said class of doctors, video order number so and so, has prescribed a standard operating procedure in SOP in short. Now the issue. The issue falls for consideration in the present writ petition is whether the department is bound to follow the procedure prescribed under the SOP to deploy and or engage the said SRs during the said bond period. Now, this is, Millard, the question which has been framed by his lordship. Now, Millard, the undisputed facts, I skip over Millard, paragraphs 2, 3.
No, Mr. Dotto, when was the appointment given? That the list which you challenged, list which was challenged
Challenged by
in
them, yes.
petition, that was of by that he was placed at a particular place in Raiganj.
In Raiganj, right.
His contention was I must be appointed in RG Court.
RG Court, because at the time of counseling, I had opted for RG Court.
Now, that was in
27th May.
27
Counseling
May
notices on
2021.
yes, 2025.
So, Mr. Dotto, you allow him to join. We will say it will abide by, we will decide the appeal.
But then it becomes academic, Millard. But if I allow him to join, it becomes academic.
He's out of any sort of engagement.
No.
He has senior resident, government bond was
The
there.
question is where will he join?
No, we will fix an immediate date, but you allow him to join. Otherwise, the entire tenure goes, Mr. Dotto.
No, tenure has not started. If he joins tomorrow, his tenure starts from tomorrow. If he joins after 1 month, his tenure starts from after 1 month. So therefore,
I see. It
yes.
will continue for a period
Yes, of course. That is the bond. He has to serve for a period of 1 year.
So where he is appointed now?
But he was posted at Raiganj Medical College and Hospital. He has not joined.
Now, today, suppose if the appeal succeeds, in that case, he has to
join at Raiganj and Millard work for 1 year. If the appeal does not succeed, he will join at RG Court and then Millard from the date of joining 1 year.
There is no scope for interim order, Mr. Dotto.
Well, I'll face contempt then.
Contempt
Well, I have to file because of this. No, I haven't filed because it is the first day. But out of is a point is only one. 871 doctors.
No,
who
we
have,
will hear you, Mr.
Well, nothing on merit, nothing on merit. Just to understand what is the matter. 871 doctors. For all of them, one process, that counseling merit.
My learned friend,
and for me,
I don't
different process.
I don't usually disturb.
It is
He has given up his case of malafide before the learned single judge. Why is he bringing in that out of 800 he has been?
I am not on merit at all. All I am saying, this is not a case of engagement or appointment. It is a case where government circular has been followed for all the candidates minus me.
Let us see, Lord.
On merit, I am supposed to be at RG Court.
but at paragraph 1, whether the department is bound to follow the procedure prescribed by the said SOP to deploy and or engage the SR during the bond period.
Now, first tell us the facts which were there, main facts in the writ petition. You have shown us the prayer portion.
Yes.
They were challenging a notification of 27th May.
Right.
Where is that, Mr. Dutt?
But the 27th May notification, your lordship will find at page 98.
Yes, what is this?
Where this is the posting, deployment, whatever is the appropriate term. Please take the first line. The undersigned is directed by order of the governor by order of the governor to say that the governor is pleased to deploy 871 non-sponsored postgraduate doctors mentioned in the annexure to this notification at column B of the West Bengal University of Health Sciences having registration, etc. But the rest are not required for the present. But my learned friend's client's name is at page 100, serial number 24.
Yes.
Now, my lord,
he was placed in Raiganj.
It was placed in Raiganj and he had opted for
RG
Court during counseling.
So, where is that decision in negation of his option?
No, there is no decision as such, which has been communicated. These are how deployments are made.
All right.
Now, please take the counseling notice, which your lordship would find at page 71. But it starts at page 70.
Yes. 70, yes.
But this is 6th of March.
Oh, the printed number.
Printed number. Yes, the printed number, not the handwritten one. 70.
Yes, 70 is.
The counseling for engagement of senior residents who have passed out so and presently under indemnity bond contract at different medical college hospitals so under the department of so following the extent provisions will be held on so schedule. Now, the most important part on which much emphasis has been laid is at page 71. The candidates The candidate should report to the venue at least half an hour before the initiation of the session allotted for the disciplines concerned. The next sentence is what we need to dilate on. The choice once made during counseling will be final and cannot be changed under any circumstances. Now, this sentence, appears to be one of the foundational stones for coming to the conclusion by the learned single judge that if somebody exercises choice at college A or hospital A, he cannot be posted at hospital B. This is one of those.
Yes.
Then, if your lordships may kindly take the SOP.
Page?
Yes. 127. But the SOP, my lords, will find, at page 127, printed page.
Page 127.
But in between, one page, I've missed, kindly permit me to place, page number 97.
Page 97?
Yes, I'm so sorry, Number after they go to counseling and after the choice, this is a self-declaration given. But this, your lordships had the pleasure to look, at the previous round, where I'll not read in its entirety. Please take, the second last line, dated 21st of March 2025, from the date of physical joining to the place mentioned above. But above means RG Kaur, if offered to me.
Page 97, to hereby opt to engage in if offered.
Yes.
So on this basis, you say that page 98.
Yes.
No.
97.
Right. This ought to have been read with the clause at page 71.
Right.
Yes.
But my submission would be the clause at page 71 binds the candidate that he or she cannot change the option once exercised.
It binds the candidate and not the state.
Yes.
Yes. So the learned single judge held against you.
Yes, on this point.
Yes.
Now, if your lordships may kindly come to the SOP, which is at page 127.
Yes.
Without troubling much, kindly take paragraph 7A at page 129.
Yes. Yes.
Thereafter, the previous paragraphs may not be relevant. Thereafter, the directorate, along with the concerned branch, will arrange for the engagement of such candidates completing the postgraduate degree at different medical college and hospital teaching institutions of the state as senior residents for initial 1 year through counseling based on merit prepared on the basis of the collected stated particulars. After completion of 1 year bond service by such candidates, with the rest I don't think would be required to trouble your lordships.
No, what are you hinting at?
Please take paragraph 7B, then I'll come back to 7A. The directorate, along with the concerned branch of the department, will also arrange for the engagement of such candidates completing postdoctoral courses at different medical colleges and hospitals, so and so of the state as senior resident since the beginning of the service, serving indemnity bond through counseling based on merit prepared on the basis of the collected dated particulars. Then please take 7C also. The directorate so and so along with the branch will also arrange for engagement of such candidates completing postgraduate diploma at different secondary tier hospitals and rural hospitals of the state as the senior residents since the beginning of the service in the serving indemnity bond period through counseling based on merit so and so. Now, 7A, 7B and 7C are almost perimeteria. The varying factors are the candidates or the status of them. But this clause has been construed and interpreted to be a clause or a condition which binds the state to post or deploy as per the choice exercised during counseling. Where, I would be respectfully trying to, impress upon your lordships that this is not a clause which has to be read as a clause binding the state to act in terms of the option.
But merit is there, Mr. Dotto.
Yes, that is kindly similar. The merit is for Counseling based on merit list prepared. Through counseling, because counseling, as your lordships know, my lord, the most meritorious candidate is called first during the counseling, who has all the choices.
Yes.
The second most meritorious candidate is called thereafter. He or she gets all the options except one, because serial number one has.
So you did call him for counseling on the basis of merit.
That is over. The grievance is not that he was not called for counseling as per his merit. May I read 7A once more for your lordship's consideration? Thereafter, so and so will arrange for engagement of candidates completing such and such at different so and so places of the state as senior residents for initial 1 year through counseling based on merits. Merit list prepared on the basis of the collected particulars. Or in other words, it says that I cannot call persons for counseling as per my whims.
It has to be on the basis
of merit.
Yes.
My lord, in the second line, the expression engagement is not qualified with merit. Rather, my lord, in the fifth line, counseling is qualified with merit.
Yes.
But may I be permitted to, my lord, add a few words to explain? May I add a few words over here? Thereafter, so and so will arrange for engagement of such candidates completing postgraduate degree based on merit at different hospitals. And then counseling based on merit. Then, my lord, it is a twofold action based on merit. Counseling will also be on merit. Engagement will also be on merit.
State's contention is this engagement is not saddled with merit.
Yes.
It is saddled with counseling for summoning them.
Yes.
Now, is it a case that in Raiganj you are the person whom you are sending at Arjikar is at a higher merit position than the candidate here?
No. He is higher than one of the candidates. Two of the candidates.
So he is higher than two, and he was called also for first for counseling.
Yes. On that he has.
And he opted for Arjikar. Now, what did the other options from the subsequent candidates who had been placed?
They got Arjikar.
They got those the other two candidates who had opted for Arjikar got it.
So how many posts were there?
In Arjikar, there are 4 posts of anesthesiologist.
So the petitioner is an anesthetist. So there were 4 posts of anesthetists. So then, Mr. Dotto, if you have allowed the less meritorious candidate who had opted for Arjikar, then what was the reason for not considering him?
Now, the reason for not considering him is that in Raiganj, my lord, there are also 4 posts.
In Raiganj also there are 4 posts of anesthesis. Very good.
2 were filled up.
2 filled up. And 2 remaining.
And he was given to Raiganj, therefore 2 plus 1, 3. If he had joined, then Milord, Raiganj would have got 3 out of 4.
Mr. Dotto, just interaction. You said that engagement is not qualified by merit. Counseling is on the basis of merit, which you have explained. It is right in all counseling. Now then, if this person was opted for Arjikor, was not given Arjikor, but the person who was less meritorious to him, he opted for Arjikor and he got it. Then why this distinction?
There, Milord, my submission was that, Milord, this SOP, Milord, cannot be elevated to the status of either a constitutional provision
or a statutory provision,
or a statutory flavor, or even an executive instruction under 162.
Then why didn't you make this provision? If you are not inclined to follow that, then why did the state make?
We are before the writ court, Milord. First, Milord, I have to, or a petitioner has to satisfy that he has a legally enforceable right. But all wrongs are not to be, Milord, rectified by the writ court. We are assuming for argument's sake that he has been wronged.
So your two arguments are, first argument is that on the basis of the counseling option which is as well, state is not bound by such option.
Right.
And the second condition, you said that in explanation of the reasoning, you say that you cannot go back to the SOP and find out what had been the faults there. First, there has to be an establishment of a legally enforceable right. So, to that legally enforceable right, what is your submission?
Yes, I have made my submissions. The Honorable Court has recorded that also.
Oh,
yes. But
So do
I
we-
have another ancillary submission to make, which is, Milord, evident, Milord, from page 97. Milord, at the declaration stage also, he was aware that he may not be offered Arjikor also. That is why, Milord, it is written.
If offered to.
If offered to him. Therefore, it may not be offered to him also. Therefore, where is the question of?
But that is the prescribed pro forma you have published.
I have done. Therefore, the prescribed pro forma itself made it clear, or made them aware, whoever it is, that the choice may not be followed by posting, or the choice may not fructify into a posting.
And he was aware of that, and as such, there had been no infringement.
And there is another point to it is,
yes. Yes, Mr. Another point is?
Other aspect of the matter is assuming that some right flows from paragraph 7A. Assuming for argument's sake.
Paragraph 7A
of the SOP. As
7A.
for argument's sake. So please consider, Milord, whether this provision is mandatory or directory. Your lordships have held to say that it is mandatory, there has to be some consequences prescribed for non-adherence.
Yes.
Now, my lord, before going to the judgment,
yes,
but I would like to, my lord, place 7-8 paragraphs of my affidavit in opposition before, my lord, placing the judgment. 7-8 paragraphs. Please take, my lord, page 144. No, sorry. I'm so sorry, Miller. This is part of my written notes. 136.
136.
136 is your opposition.
Yes.
Thank you. Yes.
Please take note paragraph number 14 at page 144.
Yes.
With reference to para so and so, it is denied that RG hospital, being the choice of the petitioner, was final or informed or was recorded as the departmental protocol, or that there was any corresponding declaration affirming the said allotment as alleged or at all. It is evident from the self-declaration annexed at page 59 that A, the option exercised by the petitioner is final, and B, that the petitioner cannot change such option, and C, the option is dependent upon the offer of posting to be made by him. In other words, the option is subject to the offer to be made by the state government. There is no document binding the state government to offer a posting as per the option exercised. Millard, my learned friend's client chose not to file a reply to this. No affidavit in reply was filed, and that was recorded by his lordship in a previous order that the petitioner does not wish to file any reply to this. But I am hinting at doctrine of non-traverse. The corollary is, it is an admission of the petitioner of what I have said.
Yes.
Then please take note paragraph number 15.
Yes.
The paragraph number 15, please come to the next page, that is at page 145. It starts from page 144. Please take the third line at page 145. It is submitted that the posting of the candidates is based on various factors, including but not limited to the requirement of candidates in each college involved in the process. No candidate is transferred to any college of his or choice, disregarding the actual number of senior residents required at that material juncture. It may be pertinent to mention here that there are other instances that the senior residents have been posted as per the requirement of the healthcare facility, etc., and in the interest of public service, and documents evidencing the same are annexed herewith marked with so and so. It is denied. This the rest is not required. This is another point I have taken, that deployment is need-based, not choice-based. Not denied. But the basic factual denials, Millard, I don't trouble your lordships. Then, Millard, that paragraph 15, I'm sorry, paragraph 16. Please take note the fifth line in paragraph 16. It is submitted that RG Medical College and Hospital has 4 posts, in which 3 have been filled up and 1 is vacant. On the other hand, Raiganj, there are 4 posts in the department and 2 posts are lying vacant. Hence, in the interest of public service, the petitioner should join, etc. Not dealt with. Then para 70. Seventh line, Millard, at para 70. He submitted that exercising option by the optee does not bind the state to post the optees at the preferred place of posting. There is no dispute that the state government has control over the deployment of the petitioner and other residents, senior residents. Therefore, the petitioner cannot compare himself with other persons in order of merit and claim for a posting at the place of choice, that is so and so. Then skipping over one paragraph, para 19, Millard, I have spoken of no right.
Para 19.
And it is about
Page
page 147, 11th line at paragraph 19, the state government.
Yes.
The state government has the right to place any person at any point of time in public interest and in view of the compulsory service bond executed by him in terms of notification dated such and such. In this connection, a requisition made by the Raiganj Government Medical College dated for minimum number of so and so necessary to provide services is annexed such and such. It is in terms of the said requisition, the petitioner has been posted at Raiganj. It is evident that the primary objective of the notification of 31st July, as read with 10th June, is to serve a significant public purpose of ensuring availability of medical services and infrastructure in rural and underserved areas. This overarching objective serves as the guiding principle for the administrative decisions taken under the notification. The petitioner has voluntarily executed compulsory service bond and availed of subsidized medical education and remuneration, where the rest will are more in the nature of the purpose. Were not denied, then please take para 21 at page 149. Where page 150, please take the last line. The order dated 16 February 2023 does not create a right to be posted at a place of posting. In the petitioner self-declaration also such and such. It's almost the same. Then at paragraph 22, we said that requirement of the college.
It should. Which is the 16 February order, Mr. Dotto? Page 149, last line.
Page 127.
Oh, that is the SOP.
SOP.
Does not create an yes.
Then, Millard, the last paragraph is paragraph 22. Please take away the last 4 lines of paragraph 22. No.
Yes.
The administrative discretion in the matter of posting of senior residents, doctors, has been exercised by the respondent as per the requirement of the college concerned.
Yes.
But para 23, Millard, I thought, Millard, I'll read, but Millard, that is, Millard, dealing with malafides. But my learned friend's client has given up, Millard, the point of malafide. Therefore, Millard, I don't press this paragraph for the time being. Now, my purpose of, Millard, showing these paragraphs from the affidavit in opposition is that whatever case I had made out, right or wrong,
non-traverse.
Not traverse. Result is admission.
Yes.
Now, your lordships may kindly take, Millard, the judgment under appeal.
Yes.
Where paragraph 1, Millard, I have placed. Then paragraph 5, kindly take paragraph 5. Where this is the cause of action. Just have a look to that.
Yes. Para 5.
Para 5. So this is the cause of action. The petitioner is alleging that in the said list, his place of posting as SR has been altered to Raiganj by changing the choice exercised by him at the time of counseling arbitrarily. The petitioner is challenging the said note.
Yes.
Then the Honorable Court records the submissions made on behalf of the petitioner Primarily the submissions are that the SOP is a standard which has been formulated by the state. Therefore, the state is bound to rigorously follow it or scrupulously follow it on the pain of invalidation. The Justice Frankfurter's principle. All these judgments which my learned friend has relied are on those. But my learned friend submissions are noted at pages. If your lordship are looking from the memo of appeal, page 4 of the judgment, it starts and it ends at page 8 top. Then, my lord, my submissions, my lord, are noted. Whatever I have said to this court, my lord, verbally, these are all, my lord, at paragraph 7 at internal page 8 of the judgment. 8, 9, 10, non-traverse also I have said, 11, 12. Then where I distinguish the judgments of my learned friend Millard at page 12. Then Mr. Thor's reply, your lordships would find Millard from page 13, 14, 15. Now, Millard, the analysis of the court is at page 16.
Yes.
Third learned counsel, the state has sought to justify the posting of the petitioner at Raiganj by ignoring the choice exercised by him during counseling on the ground that the SOP is an administrative instruction having no force of law, least of a regulation. As such, the state is not bound to follow it as the procedure does not confer any right. Therefore, it is not enforceable. The state action is under challenge. To decide the sustainability of the challenge, at first, it is necessary to introspect the scope of judicial review to such administrative action. No doubt, the scope is very limited. The law is well settled that it is not open to the court under judicial review to examine the validity of the decision, but the court can examine the correctness of the decision-making process. The Honorable Supreme Court in the case of Keshavananda Bharati has held that in such case, the court reviews the constitutionality of an administrative action and also examines its fairness, reasonableness, and justness. We're pausing here for a moment, Millard. My learned friend will correct me if I'm wrong, but this is a judgment not relied by any of the parties. Keshavananda Bharati, Millard, was not relied by any of the parties. I would request my learned friend to correct me if I'm wrong.
Keshavananda Bharati not be seen based by any. This is as good as reading the constitution.
Yes.
Please take the next paragraph. The Honorable Supreme Court in the case of Tata Cellular versus Union of India has considered the applicability of evidence principle in judicial review. Again, we have a judgment not relied by either of the parties. Then paragraph 11, my lord.
Same principle,
Same
decision making process.
Yes, from Tata Cellular. Then, my lord, after quotation in paragraph 11, the Honorable Supreme Court, following the same principle in case of so-and-so, has held that it is not permissible to the court to examine the validity of a decision, but the court can examine the correctness of the decision-making process. Again, my lord, subject to correction or judgment not referred by any of the parties. But I'll come to this point later on.
Yes.
Now, please take note paragraph 12. Keeping such scope of judicial review in administrative action of the state in mind, let me now examine the issue under consideration. A plain reading of the SOP would clearly indicate that it prescribes a complete mechanism to get the service of the SRs during the bond period smoothly and without any dispute. Therefore, it is not correct to say that the said document contemplates two distinct aspects, that is counseling and posting, or the choice exercised during the counseling would not directly reflect in the posting. We are pausing here for a moment. Please recollect your lordship's earlier decision. The entire submission was that there is no scope of posting. I lost on that point. Now we are in the second round. The decision is based on irregularity, so-called irregularity in posting. It would suffice to quote para 7a, but then para 7a is quoted. Now kindly take me to para 13. The SOP without any ambiguity prescribes that posting would be preceded by counseling based on merit. Milord, on the earlier occasion, Milord, we had dealt in extenso the difference between posting deployment. Milord, I could not succeed in impressing upon the Honorable Single Judge as well as this Honorable Division Bench that it is in fact the posting. Be that as it may, Milord, today, Milord, the decision is made on the anvil or the principles of posting.
Yes.
The SOP without any ambiguity prescribes that posting would be preceded by counseling based on merit. Obviously, such counseling is aimed to achieve the principles of fairness and transparency, as held by the Supreme Court in Bhavna Tiwari. In the present case, the state, following the mandate of the SOP, has posted 869 out of 871 candidates in the hospital opted by them at the time of counseling, but such mandate has not been followed in the posting of the petitioner and any other and another candidate, and in doing so, the state has compromised with the merit.
Para 13 you are reading?
Para 13, Milord, I am reading. But I really, Milord.
Para 13?
Yes, ma'am. Para 13, Milord. Please take 1, 2, 3, 4, 5, 6, 7. Please take, Milord, the 8th line. Where the middle of a sentence. And in doing so, the state has compromised with the merit. But I ask a question to myself, but how have I compromised with merit? Whose merit have I compromised? Have I compromised the merits of the patients?
No, his merit ranking was 24.
Yes.
He was given to Raigarh.
Yes.
The next person in 25 ranking was again placed in RG.
Right.
So you have compromised on merit.
Merit of my lord, may I, I'm not possibly, my lord, clear. My lord, in order to say,
Rank 34, my brother says, rank 34 also gets,
yes, yes.
and you negate this saying that this, no, we just, when the government is posting him to Raiganj, in negation, because engagement and merit position, counseling will be on the basis of merit, engagement will not be on the basis
This
of
is
merit,
one
which you
part
have
of my
argued.
yes. This is one part of my
That has been negated by the single
Yes.
judge, saying that you have compromised on merit.
Yes. Now, compromising on merit can happen when? It can happen
if the engagement is qualified with merit.
That is where the interpretation of 7.
Eh.
But on a broader aspect, please consider, Millard, compromise on merit can happen only in case of service.
But that chapter is over, Mr.
Yes,
Datta.
now in the principles which have been applied in the previous chapter, a different principle is being applied in the second chapter. But I do not know whether res judicata will apply or not, but the principles would apply. That res judicata applies in the two stages of the same proceeding. If it is not called a posting in the earlier round, it cannot be called a posting in this round. And in order to negate my action, the principles of merit.
Then is it not a long drawn submission which you are arguing, Mr. Dotto? Because that issue has rested on the basis of the judgment of the coordinate bench, which has not gone up in appeal.
No.
So therein the dispute was pertaining to the terms deployment and posting, wherein your argument was that it is a posting, you go to the tribunal. Mr. Dhar says that no, in this case, and that Rahul Bansal or something.
Right, right.
But that issue, Mr. Dotto, how can you apply here?
No, I'm not applying it. I'm saying that the court is applying a reverse issue or a reverse principle. Therefore,
In deployment also, Mr. Dotto, there may be a compromise.
May I say this, Miller? The Honorable Court does not say. The Honorable Court does not say. Please consider one thing. Today, Millard, I cannot argue before your Lordship that I posted this person over there. I cannot argue because I have lost in the earlier round. Therefore, I have to argue that this person has been rightly deployed at that place. Therefore, your Lordships have to consider whether he has been rightly deployed at a different place or not. Your Lordships cannot consider today whether he has been rightly or wrongly posted at that place or not.
Very good.
Now, the Honorable Single Judge is considering today what? Not the deployment. Today, the Honorable Single Judge is not considering whether the deployment is in accordance with SOP or not, or the other principles. Today, the Honorable Single Judge is considering, because Millard,
the posting is argued.
Yes, because your Lordships have not held that posting and deployment are synonymous. But I am making this submission, take it as a submission made 25 times. That deployment and posting are not synonymous. If they are not synonymous, then the guiding principles for posting cannot be applied in a case of deployment.
In deployment, if there has been a compromise, it cannot be interfered with. Suppose in deployment, taking cue from your argument, the deployment was made. In deployment also, had there been an arbitrariness, can the court...
Millard, all arbitrariness, Millard, springs from a right. Why this is black and not white, that cannot result in arbitrariness. Therefore, my lord, my respectful submission is that the principles applicable.
You cannot apply the principles of posting to deployment as has been upheld in the coordinate.
Earlier.
This is your.
Yes.
Next, anything
But
else?
the other aspect of the matter is, which is connected with the posting.
Yes.
Once you say posting, the discretion is always with the employer, because an employer posts.
Yes.
Therefore, if it is held, irrespective of what 7A, what should be the interpretation of 7A, irrespective of that interpretation of 7A, all along, my lord, posting is a prerogative of the employer.
Yes. Yes.
But I have given my reasons, right or wrong, I have given my reasons through the affidavit, which the portions which I have placed. If this is not traversed, what is the result? But I can understand where there is a dispute. I say, I am right.
Mr. Dotto, you are the state. You will go by these technicalities.
No, it's not technical. It's a basic principle, Miller.
Principle is that
Miller,
your action itself is under challenge. You are justifying your action by saying that you have not traversed my argument. But you are the state. You are the model employer. Can you take this plea?
But again, your lordship is saying model employer.
Yes, you are a model employer.
No,
but the
Miller, as a state, I have various functions.
No, your
I enter into contractual field. I construct roads. I appoint people. I provide education.
Now, one thing is whether you have the right to do so. That is one thing. And the next is how you exercise such right.
Right.
When you are exercising such right, it ultimately boils down to the issue that you are acting on the basis of the option exercised by a below ranked candidate in a particular manner.
Yes, that Millard, whether Millard, number one is whether Millard I can do it or not. Number two, when I say I can do it because the SOP does not prevent me.
That you have argued.
Yes. And number two is he has to show that he has a right to be posted at the place chosen.
Irrespective of that, if the action appears to you have taken an action, suppose my brother is at rank 40, I am in a rank say below my brother, then you are calling my brother to exercise the option. You are accepting my brother's option. But in my case, you are not accepting.
Could your lordship permit me to give an example without taking me amiss? In all courts, including our court, Millard, we have the judge's seniority. The point of discrimination, Millard, cannot come from a vacuum. It has to come from Millard some legally enforceable right. 7A does not say that posting must be as per the choice. It says counseling must be as per the merit.
Yes.
But I could have understood that 7A is challenged.
Yes.
Yes.
Anything else?
Yes. But let me finish this judgment. Then the state has compromised with the merit inasmuch as so and so in rank 26, so and so having rank 34 has been posted in the hospital opted by them at the time of counseling, so and so, so and so. The state has sought to interpret the phrase if offered to me appearing in the self declaration of the petitioner to mean that it is the prerogative of the state to offer a seat unless the offer is made, the choice made in the counseling is not binding. This court is unable to accept such interpretation of the phrase as it would render the procedure prescribed under the SOP in the matter of deployment of the SR nugatory.
Observation finish. Observation টা ঠিক।
Clause. Your lordships will not provide reasons for making an observation or rendering a finding.
Next line.
Kindly see, the logical interpretation of the phrase should be that the candidate must secure the merit position to get the offer according to his choice. The logical interpretation.
Yes.
The state has sought to justify the said deviation from the SOP also on the ground that the hospital where the petitioner has a higher requirement for an SR is the relevant discipline than the hospital opted by the petitioner. The justification is too feeble, inasmuch as the deviation, if necessary, would start from the last ranked candidate. The Honorable Supreme Court in Asha Supra has held that higher the competition, greater is the duty on the part of the authorities concerned to act with utmost caution to ensure transparency and fairness. It is one of their primary obligations to see that a candidate of a higher merit is not denied seat. But I do not know how these principles apply. Educational principles will apply in the deployment or posting and say that their merit is compromised to the appropriate course and college as per his preference. So the principles applicable to the students, in my respectful submission, would have to be applied to the teachers as well. Now kindly see, Milord, how the learned judge, Milord, deals with the decision. The state has not disputed that it is bound to follow the principle laid down by the United States in the case of so-and-so, but has refused to apply the principle in the present case, alleging that the SOP, being an administrative instruction issued only to regulate the service of SRs during the bond period, lacks the force of law, even of a regulation, and as such not tenable. Pausing here for a moment, Milord, William Vincent is, Milord, a case of dismissal from service without following the rules.
Yes.
Well, in the first round, I have been shown the door saying that this is not a service matter. Please take the next line. The Constitution Bench of the Honorable Supreme Court in the case of Sukhdev Singh has held that even if the regulations have got the force of law, the principles laid down in Vincent should also govern the situation. But Sukhdev Singh again is a case of removal from service.
Yes.
Then we have para 16. The SOP is a tool designed to achieve the right guaranteed under Article 14. Even if the SOP is an administrative instruction, the state is bound to follow the ethos of Article 14 to eliminate arbitrariness in the state action. In the case of Amarjit Singh Ahluwalia and Ramana Dayaram Sethi, the Honorable Supreme Court has laid down the principle that the nature of administrative instruction not having the force of law, but the state government could not at its own sweet will depart from it without rational justification. The said principle is equally applicable in the facts and circumstances of the present case. But if your lordship recollects Dayaram Sethi's case, there are two things. Number one is it was a case of tender. And number two, finally, Milord, no relief was granted. In Ramana Dayaram Sethi, where the Supreme Court finally, Milord, did not interfere with the process.
Yes.
Then kindly take me para 17.
No, para 17, yes, Minhas.
Milord, B.S. Minas again is a case of appointment. Appointment in ISI.
We have now para 18, your judgments have been
Yes.
taken. So, Mr. Dotto, you conclude your arguments then. You can summarize.
No,
and
no, no. I need to, Milord, this again, Milord, has to be noted. That my judgments are distinguished, saying that these are on so and so topic, therefore not applicable. But the judgments of the petitioner are not considered topic wise insofar as the applicability is concerned.
Yes.
Kindly similar to how my judgments are being now distinguished.
Very good. That is the procedure followed. We understood.
Yes.
Now, Mr. Dotto, you summarize your argument.
Yes. Now, just a minute. Give me permit to read the last paragraph. Conclusion.
Yes.
Summing up the discussion made above, this court holds that the decision of the state to deploy the petitioner at Raiganj clearly violates the Wednesbury principle. Thereby, the state has committed a serious wrong which demands intervention. Accordingly, the issue is answered in the affirmative. As a result, the impugned notification dated so and so and the list so far as the documents related to deployment of the petitioner are set aside. The department is directed to deploy and or engage the petitioner in the second vacancy so and so.
Yes.
First submission is, Milord, Wednesbury principle was not argued.
Yes.
Second is, Wednesbury principle is gradually taking a back seat. Now it is the doctrine of proportionality. Milord, the learned judge, Milord, has not applied the doctrine of proportionality or the corollary as to how disproportionate is the order.
Yes.
Therefore, principles not argued, Milord, has been applied in a judgment. But in all fairness, the learned judge ought to have framed it as an issue and invited the parties to make submissions on it. Then, Milord, your Lordship may kindly take, Milord, the sheet anchor, that is para 7A. The learned judge, Milord, has quoted 7A, applied 7A, came to the conclusion that 7A has been violated, but Milord does not render any finding as to which part of 7A I have violated, or which part I have made nugatory. But I have a submission. That submission can be negated, no doubt about that. But the submission that
there has been a violation. What is the violation?
Yes, but my submission was that choice is merit based. I'm sorry, counseling is merit based. Posting, deployment, engagement, everything has been confused, whatever it is.
It is the discretion of the state.
Yes, that is not merit based. With respect, Milord, that point, Milord, has not been, Milord, dealt with by the learned single judge.
Yes. At para 13.
Yes.
All right.
Then, my lord, assuming that 7A confers any right, assuming so, my lord, it is directed in nature. There has to be some provision providing for the consequences of non-observance. Not
That you have argued. That
yes, but
consequences.
I'm just collating, my lord, my points. Just collating the points. But I'll request your lordships to look into my written notes of arguments at page 127 of the stay application. But these are all points taken, Millard. I'll be this
127. 127 is the.
yes, I'm sorry. It's sorry. It starts at page. No. I'm so sorry, Millard. But I've noted out the wrong page number. I'm so sorry, Millard. Millard, it is 269. I'm so sorry. Well, whatever I've argued, Millard, these are all
That
points.
has been given here, 269.
These were filed, Millard, before the learned single judge. Then the next point is, Millard, what is the effect of non-traverse?
That you must have taken in your. That we will seek his response.
And Millard, most importantly, Millard, what happens, Millard, if the court decides on by relying on judgments which are not cited, or neither, Millard, the parties are called upon, but it often happens where your lordship finds that I have missed a judgment. After conclusion of hearing or during hearing, your lordships say that such and such judgment is there. We want you to address the court on the applicability or non-applicability of this judgment. But if this is not done, then what happens? But our High Court single bench, of course, Millard, has held, Millard, this is a procedure which infringes natural justice. Our High Court single bench, Millard, it has a persuasive value that relying upon a judgment without calling upon the litigants or the parties, court relying upon a judgment without calling upon the parties, Millard, to make their submissions on the judgment, infringes natural justice. Because after all, I am also a party, maybe the state. But your lordship, just have a look to, Millard, 2 lines of 1 paragraph. This is 2008 3 CHN 998, but this is an honorable single bench judgment.
Yes. Which paragraph?
Right, paragraph number 5, please take away the last 5 lines. Here, Millard, the learned Judge Millard had taken note of a judgment which has come into effect post-hearing. Then the court says, natural justice not only means right to be heard and be represented, but also to provide an opportunity to deal with the judgment and or order relied by the tribunal or authority. Absence of opportunity to deal with the order as it has happened in the instant case makes the order vulnerable.
Yes.
Well, we have also distinguished, my lord, please take note of, my lord, another written notes that we had filed. We're dealing with the judgments which my learned friend had cited, which is at page 277.
All right.
And my lord, though my lord, I had said many things on malafide in my written notes, but since it has been given up,
He has not urged that.
yes, but that my lord, the learned judge my lord has noted. Just look into that sentence, my lord. না জাজমেন্টে আছে একদম শেষের দিকে আছে it's at page 23 of the judgment. Last two lines. The petitioner has not made out a case of malafide, therefore the decision of the Supreme Court in the case of so-and-so has no application.
Yes, Mr.
But I have a very short submission. I got the written note that I filed, which is part of the record. I have not added anything. Only pages would be different because it was the pages from the writ petition itself. I just referred the pages from the stay in case there is a requirement. Well, first, the
copy to Mr.
That is part of the record itself. Yes, even then. Because this is with part of the record, only pagination is of writ petitions. Just to make it easier, in case there is a necessity, I gave the pages from the stay application. Well, first, what is the fundamental fact? Two aspects, which is not denied. My ranking is, there are 4 vacancies at Arjikor, not denied. So therefore, 4 persons can be there at Arjikor. No difficulty for that. My ranking is 24. There are 3 other persons, one above me, ranking number 13, and after me, that below my ranking 26 and 34, all got at Arjikor.
No, 3 others, 13, 26 and 34 got in Arjikor.
13 should get it because 13 is better than me.
13, 26, 34, there are 4 vacancies.
Yes.
And the other one?
Other one still vacant. That's the reason I said that you don't have to suffer anything. Even if you should have complied with your own SOP, I say that I don't want someone to pull down. Whatever you have done, whoever is below me, I don't mind. Let him be there. I say that your existing number of vacancies are 4. And I stand at number 2. Because my ranking is 24, I come just after 13. So you are allowing 2 persons who are after me. That's my fundamental point.
Was there any interim order not to fill up any?
No, there was.
It is still vacant.
It is still vacant. It's still vacant. Now, the other interesting part is total number of candidates were 871. This merit has been followed for all 869. Only 2. The other one who also filed the writ, that is his yet to be, because it was taken up first. I don't mind that state taking a stand that I have a right and therefore I can send anybody to anyone. I don't mind that.
This 871
is the total number of who passed. System is, it is not an recruitment. Because we have...
No, total was 871 in respect of how many it has been followed.
All 869, excepting 2 filed writ petitions. One is already over, other is, it is in the midst.
Which before the single judge?
Yes, before the single judge.
The same point is there.
There was a difference because in his case he joined, and in my case I sought leave from this honorable court, and I so therefore he was not suffer, because in my case, like, but if I am at home for 1 month, just like we understand, my lord, last month we had the vacations. On the first day,
in the other case, he joined the
he
post
joined.
at Raigad.
Yes, that's the reason the honorable single bench thought that this is it requires an expeditious hearing, because this is the situations. My situation is this, my lord.
Which requires an expeditious hearing?
My case, because of the reason
that you have not
because
yet
my role is only in the operation table, and if I am out of the operation table for 1 or 2 months, just like our profession, my lords, if someone is out of practice, my lord, this I will lose my age, I will lose so many things, which it is very difficult to come back to that stage. Now, kindly straight, I think so. Therefore, these are not disputed things. That number of vacancies 4, I stand at number 2 candidate, and number 3 and number 4 who are below me, they were accommodated following the same SOP. Now, this entire submissions of learned advocate general in one sentence is SOP for merit relevance is for counseling, not for engagement. This is factually incorrect. Kindly look at 7A quoted in paragraph 12.
Paragraph 12.
Paragraph 12, this SOP 7A has been quoted, so I'm referring for convenience. Paragraph 12 of the impugned judgment. That exact portion is at page 129, but Lordship may get it easily because it is quoted there.
Yes.
Kindly take, my lord, I will kindly read, my lord. 7A. Thereafter, the Directorate of Medical Education, along with concerned branch of the department, MERT, will arrange for engagement. Kindly pause. Will arrange for engagement of such candidates completing postgraduate degree at different medical college and hospitals teaching institutions of the state as SR for initial 1 year through counseling. Kindly mark the word through. For engagement through counseling. Now, how is based on the merit list prepared on the basis of? So therefore, the entire counseling is for engagement. Counseling is not for anything other than for engagement. To say that counseling is for counseling, it only would take us that then for engagement, there is nothing. Then there would be no meaning of the word through. So arrangement for engagement, so that, well, since this is not a recruitment, the number of candidates who study from all over India, this is one of the things they get to know at the time of admission, that after I complete for 5 years course, thereafter 1 year I have to serve. Now, why everyone, my lord, wants to be in a better colleges or a college where more number of complicated cases they would be able to deal with? Because they know if I am at RG Corps, then my exposure to the complicacy would be much more. I will learn much more. There are variety of disciplines which are not there in the states. Now, everyone will ask for it. Then how it has to be dealt with? That's a 7A. If you have a merit, then you can get it. Well, I don't say, I could have the interpretation of if what is the exact words? If allowed, if offered to me, that means, for an example, I opted for RG Corps. but I don't have the ranking required, then of course it will not be allowed to me. That's Article 14. Nothing is required. Well, there has to be a mechanism. When this pool of 871 candidates, they know the number of vacancies, it's how it has to be done. If I read once more, paragraph 12, the 7A portion, if I read, my lord, by leaving unimportant words.
No, what did the court held to that? What is the court's observation to that?
Yes, my court's observation is paragraph 12 and 13 is this. First, paragraph 12, court held, this is 7A exactly. 7A exactly means this is will arrange for engagement and this has to be on merit. And then 13, court has addressed that you have deviated from the merit. Why and how? Because there are two other persons whose ranking were below the writ petitioners. You have accommodated them at RG number one. And number two, you have done and followed the same SOP for all the 869 candidates. So therefore, to make out a story of discretion, now that doesn't have any.
Mr. Dhar, suppose merit is one thing,
yes,
and exercise of choice is one thing.
Yes.
For counseling, you have to call on the basis of the merit.
Correct.
So I appear, I choose Arjikor.
Yes.
Another candidate who is next to me on merit.
Yes.
Say he does not choose Arjikor, though it may be a better option, he
Correct.
chooses Raiganj.
Right.
So then if this crystallization of deployment on the basis of counseling strictly, as you are saying, is to be understood,
yes,
then in respect of engagement, this does not come, which you are saying that this counseling mechanism is included within the mechanism towards engagement.
Well, why I say so? I have understood lordship's.
Am I, I think, have I explained myself? Suppose you are hiring rank 2.
Yes.
You have been done this wrong according to you.
Yes.
Now I am next to you.
Yes.
Though I am entitled to Arjikar, I choose Raiganj.
Correct.
Now this engagement, if it is to follow the counseling, that state has no option to consider that whether on the basis of the counseling then he has to be placed, or we can exercise our own discretion.
No, madam, I have understood. I think, my lord, some factual thing as said by learned Advocate General, I need to clarify that.
Advocate General says that the term engagement is not qualified with this merit issue. This is a discretion of the state.
Yes.
Leaving about his other argument,
Correct,
whether
correct.
deployment or
Right,
posting, etc.
Yes.
He says
Yes.
that how can the candidate say,
yes,
ask the state
yes,
or compel the state to exercise discretion, since on merit he has been called for counseling and chosen Arjikar.
Malad, here lies the, may I have understood now. I have understood. May I start from the zero for this point? Malad, this is a brilliant submission. Now, this submission presupposes that merit is for counseling.
That is his call.
Yes. But that is not the fact.
Coupled with the issue.
That is not the fact. The counseling.
Counseling is on the basis of...
First, the counseling is an English word for a purpose.
Right.
Counseling, how we call it, that doesn't matter. Counseling is a mechanism. Now, if I put a question to myself, for what? Is counseling for counseling or counseling for something else?
No, counseling is a right given to the candidate to choose the vacancy.
Yes, to choose the vacancy.
Now, if the second candidate, his parental residence is in Uttar Dinajpur.
Yes.
Even if he is inclined to get RG card, he chooses Uttar Dinajpur.
Yes.
In that case, what the state is to do? If the state is to consider merit, then you cannot place that candidate at Uttar Dinajpur. You have to place it on the
No.
Archikot.
May I say this? May I say this? My lord, the counseling up to this part, my lord, there is no divergence. That counseling is a mechanism.
Yes, that
Now,
you have argued.
yes.
There is a mechanism.
It's a
for
mechanism.
engagement.
Now, it's a mechanism for what? That answer, before giving any interpretation to that, if Lordship look at that, state has made at the SOP a mechanism. In the mechanism, two things they do. One is collection of the vacancies and declaration of them same. Like for RGCOT, there are phone number of vacancy. So therefore, transparently, it is known to all 871 persons. Now, out of 871, there may be 10 persons who are willing to opt for RGCOT.
Yes.
But state cannot give all this to 10. They have to restrict it to 4. Now, which 4? That's the point here, is which 4? I say that first 4. And when I say the first, I say based on merit. Why do I say so? Because of the words through counseling. Mala, this is not full stop. Through,
Continuation.
yes, through so counseling is a mechanism. Through counseling, based on merit list. What for? For engagement.
All right.
Mala, that give.
So your contention is that the mechanism which was followed in respect of 869 candidates was suddenly made topsy-turvy in case of one.
Yes.
And counseling is in fact included within engagement. The engagement is on the basis of the mechanism of counseling.
Yes.
What about non-traverse, your argument?
Yes, my lord, for long traverse, the fundamental. Kindly take my note.
No, before that, Mr. Dotto argues that this observation interpretation has been negatory. How the court said that? Page
But
300.
yes, it is. Kindly look at this. I could have understood that the learned single judge has ignored this 7A. Now, once the learned single judge quotes the 7A, and when I say the fundamental words which are operating is the through and arrange for engagement, my only interpretation is that the learned single judge has bodily lifted that what is the heart of the matter, and thereafter found that. Kindly look at the logic is, according to me, it was, my lord. Kindly, may I read paragraph 13? Kindly start from, my lord, after 4 lines. So first, entire 7A relevant portion. Thereafter, from 4th line, in the present case, the state following the mandate of the SOP has posted 816. Here the word posted. In the conclusions, the word deployment has been used. Now, my lord, while giving dictations, I don't think we should give too much of importance to that, because ultimately in conclusions, the learned single judge has used the word deployment, though here the word has been posted. SOP has posted 869 out of 879 candidates in the hospitals.
Is you are applying the principles of posting to deployment?
No, it's not that.
That is his argument.
That is, in my understanding, that is a too hyper technical point. It is to say that just because Article 14 has been applied, if I give a metaphorical example, for a case of handicapped situations, as if only in case of handicapped situations Article 14 would be applicable. No. Article 14, if it is there, it can be there in the service matter, it can be there in the contract matter, it can be there in some other matters also. The heart of the matter is, has there been
decision making?
Yes, decision making process. This, kindly take paragraph 13, this portion, from 4th line, starting from just after the Vabna theory, that quote. In the present case, the state following the mandate of the SOP has posted 869 out of total 871 candidates in the hospitals opted by them at the time of counseling. But such mandate has not been followed in posting the petitioner and another candidate. And in doing so, the state has compromised the merit in as much as Dr. Such and Such having merit rank 26 below me and Dr. Triponna
That
Chattopadhyay.
Mr. Dotto says that compromise will be a principle attachable to the issue of posting, not deployment.
Mala, this is to say that Mala, this is I don't think but still if I so my lord, learned advocate general's point.
Answer is a general answer.
Yes.
That when there is
Yes.
arbitrariness,
Yes.
irrespective of deployment, service,
Yes.
anything else, that has to be
Yes.
done. This is your
Yeah, absolutely.
Next, what is your argument on
On non-traverse. My lord, kindly take page 13 of my note.
page 13?
Yes. Well, the last bullet point.
Non-traverse.
Yes. Well, if I can just read the first this paragraph, some portion.
If you point bullets to the court, then the result will be otherwise.
Bullet, when without the word points, it becomes a bullet. But the moment the bullet and points, it becomes some exercise which is
Yes.
tedious for us.
Non-traverse,
But
yes.
it is easier to understand. Well, this will be applicable only when burden is shifted and reply ought to have been filed. In the petitioner, all the contentions made fundamentally based on SOP, ranking being 24, total number of vacancy being 4. Out of 871 candidates, only deviation has been made for 2 candidates. In the affidavit in opposition, none of these fundamental facts have been disputed by the state. Therefore, I bank my case that this is, well, I have given up my case. I said that I don't need to argue on malafide because I had one paragraph on that he was singled out because of the reasons that he was at the forefront in the quote and unquote Arjikar movement. But I said I don't require to make any statement on that. Why? Because to my understanding, my case was clearly covered by the state's own principles. I don't say that state, they don't have any right to change it. Tomorrow they might make for the bond candidates, they might say, instead of through based on counseling on merit, they might say also as per choice of the state. Then many candidates all over India, they'll think twice before coming to West Bengal hospitals. Today, what happens, my lord? When I enter into this admission, I get to know my entire structure. This is my course.
If a
Merit,
higher rank, hear me.
Sorry.
If a higher ranked person opts for a lower rank or a lower hospital, he will necessarily have to take a higher rank hospital simply because he has a higher rank.
That is what we were asking.
Mala, there is, I have understood. Mala, I think there is no such thing higher rank hospital, and there is only a thing called higher rank in education.
Let's put it as
Choice. Now the choice is a freedom.
So let's not get into the
No, I say the
academics of what.
No,
choice.
I'm trying to say I may like to be at Medinipur. That could be my choice. Somebody's choice could be at Arjikor. But what I choose, state doesn't interfere. So choice is not defined. What's your choice? But your choice.
State can interfere.
If I don't have a merit.
No. What my brother is saying, suppose rank number 2
yes
chooses Arjikor.
Yes.
I am the first rank holder.
Yes.
I also chose, or rather we can put it, the choice is made by the candidate. Suppose a lady candidate is there, his family resides at Uttar Dinajpur.
Yes.
meritoriously she will come within the fold of Arjikar.
Correct.
But she chooses Uttar Dinajpur.
Then she will get that.
That
If
is
she has the merit.
Right. So then choice overrides merit. That's
Yes.
exactly what I asked. You said no.
No, I said no because of the reason it doesn't override merit. It is based on merit. Kindly think twice.
It's not based on merit.
No, it is based on merit because when that lady is asking for, kindly.
Are you saying that if I am higher in the as a merit rank, then my choice gets
Yes,
precedence over
not
everything?
otherwise. Not, it doesn't override. It's a prerequisite. To exercise my choice,
you have a right of precedence.
I have a right of precedence.
On the basis of merit.
Yes, yes, yes.
But Mr. Dotto says that if you saddle this engagement peremptorily with the choice exercise, you are interfering with the state's discretion. Because the clause says that engagement is irrespective, engagement and merit has not been brought on the same fold. That discretion is left.
Well, to make that argument, what Mr. Dotto has made, a new SOP has to be framed because Lordship has only one SOP. What?
Yes.
But my learned friend is harping on this choice, and he had said that if 10 people choose Arjikor, then the first 4 will get. Or the most meritorious 4 will get. First is where there is no scope of 10 people choosing Arjikor. Why? Because in the counseling notice itself, it is written that there are 4 vacancies only. Therefore, the moment the 4th person chooses Arjikor, there is no scope of any the 5th person to choose.
No, that's a technical thing. One person might wish. It might wish. That's a technical
now
aspect.
state's discretion. Now, if your Lordship may kindly take me, Lord, page number 74. Let us just give an example.
Page
74.
72.
74. But this is the counseling list. Where towards the middle, Millard, your Lordship would find Millard Arjikor.
Arjikor, yes. 4.
4. Now, if 10 people chooses Millard Arjikor, come to the last. Profullo Arambag MC. There are also 4 vacancies. Take an example, nobody has chosen at the end of the counseling, nobody has chosen Profullo. What happens? Can I not post anybody over there?
Muhammad Aziz, who is above me, he got it. Then 24, it's me.
13.
13, 1, 3.
13 got it.
13 got it. Because 13 is basically number 1. Then 24 is me. I am second. I have not got.
You have not got.
No, I have not got.
So you exercised Arjikor.
Of course, I exercise.
Now, who are the others?
Others are 26, Antora. and 34 Triponna.
আর কি 4টে ভ্যাকেন্সি তো খেয়ে গেছে তো, আর কেউ তো পাবেও না। তাহলে you will be in court on 3rd?
Yes.
Monthly list 2 p.m. করে দেবে। 3rd 2 p.m. But hopefully the post will not be filled up, no?
No. Well, until the next academic session ends.
Well, this is not the regular recruitment. This is only the bond service.
All right, thank you. Yes.
Thank you, Lordship. Not a very small prayer. The division bench of this court has asked an order kindly come to the order that page.
নাম্বারটা বলুন হ্যাঁ সব যে কোনো কেনে আছে
111.
110.
Our application is 80. But you have a different application.
Which one are you placing, Mr. Vatta?
can 30 and 31
Can 30.
30 and 30
Similar, I am pressing can 29. So
the same.
29, 30, 31.
30 same
And Mr. Bhattacharya is in 30 and 31.
So who
So
is
kindly
opposing?
take up 30 first, my lord.
You are there. Opposing.
I think he will support.
You are supporting.
Always none.
Then what order do you want?
My lord kindly sees my lord's order taken.
Pass that order.
11th of July.
Dispose of the writ petition also.
11th of July 2025, this court failed to let one expert body which she appointed to come to a conclusive decision. 11th of July 2025.
Just. 11th of July
25.
In the present appeal, order was passed.
Yes.
Yes.
Application is my lord looking at it.
can 30 or 31 any application
ওই অত বোধা নামিয়ে দিন ওখান থেকে
যে কোনো একটা অ্যাপ্লিকেশন নিলেই হবে
কোন অ্যাপ্লিকেশনটা স্যার প্লেস করছেন
একটাই তো order
না না প্যাজিনেশনের তফাৎ হচ্ছে তো
একটু তো
30 না 31
Yes, Mr. Vatta.
The minutes of the meeting of the subject experts in English language and mathematics are produced and on perusal, the original returned to learned senior counsel appearing on behalf of the appellants. The subject experts in the resolution have opined that the concerned questions pertinent to pedagogy both in English and mathematics are to be examined by an expert. Experts thought without some other expert who are not conversing with pedagogy, they will consider. This was to be done, and I believe it has been done. Only the report be placed. So that
There was a time limit of 3 weeks. It's been
further
14 weeks.
proceeded with by these petitioners.
পরের
And
প্যারাগ্রাফটা
this was only without that it should be done within period of 3 weeks from the date. Mr. Sanyal can enlighten whether the experts were appointed referred.
অ্যাডভার্টাইজমেন্ট দিয়ে দিয়েছি আরে সেটা তো পরের কথা আগে সেইটা হোক
ওটা দিয়েছে রিপোর্ট দিয়েছে রে
হ্যাঁ
কপিতে না আমাদের একটা এটাই হবে না
ওরা দি পিটিশন গুলো টেনে নি
হ্যাঁ
ওরা দি
So it is a 3-member committee to be constituted. That has been done.
No, I'm told Mr. Sanyal can enlighten whether
Then what you are wanting, Mr. Vatta?
the final report of the expert committee on the basis of which will not the further action can be taken, whether we are entitled to
get number
So that is ready, Mr. Sharma?
everything is ready but I have one submissions to your lordship. This is then disposed of appeal. Now page
Disposed of.
can I kindly come to the first order of the appeal of the division bench at page 93. Starts at page 93.
ডিসপোজ অফ অ্যাপিলে ওনারা অ্যাপ্লিকেশন করেছিলেন সেই অ্যাপ্লিকেশনে কোর্ট অর্ডার করেছিল
Now your
এই
lordship
এই অর্ডারটা ইটসেলফ ডিসপোজ অফ
I'm not placing that by this order, modifying the order of the learned single judge, the committee was appointed. Your lordship kindly
এই
come to
অর্ডারটাও
the
ডিসপোজ
internal page 9 of the order, judgment,
এই অর্ডারটা
page 98, running page. 98, may I just read out your lordship? This is judgment dated probably 23rd August. 98, we therefore modify the impugned order to the extent that instead of the submitting the views, reports and opinions by the board as well as the writ petitioner independently, the issues can be referred to a committee consisting of one member to be nominated by the board having a proficiency in the subject in relation to the question over which the dispute has been raised, one member from the University of Calcutta in the relevant subject and one member to be nominated by the Vice Chancellor of the Vishwabharati University having a knowledge and expertise in particular subject.
We are concerned that there would be a multiple committee as the dispute has been raised on the several questions and the answers is given for it. But in our opinion, it would bring a quietus to an issue and percolate a sense of fairness and transparency. The nomination shall be completed within fortnight from date and the communication of the order by the respective authorities. The state shall provide a logistic committee to logistic support to the committee members and shall pay and according remuneration. With this direction, the aforesaid appeals are disposed of. We expect that the Reef Court to decide the matter on merit after the reports are filed by the committees within a reasonable time. But these committees file their respective reports in respect of all the questions. Now, only in respect of 7 questions, they say they are somehow related to pedagogy. And these members doesn't have that expertise in pedagogy. So they find that other members should be recruited. Now, your lordships, we have to approach this honorable court because the division bench said that we have to approach the learned single judge. We approach the learned single judge with the report of the committee. That this is the opinion of the committee.
After this order.
After this order. Now, this committee, your lordships, the honorable single judge was of the view, since the order was passed by the division bench, it should approach before the division bench.
In a disposal of
appeal. Will find page, my lord, if I'm not wrong, 102, one order, and the other order, your lordships, at page 105.
The final order 110.
That's then your lordships final order to serve 98.
No.
Then we may mention the matter before the division bench. Division bench was initially of the view, since we have already disposed of the matter, we are functions of.
Who are you? You are the board.
So this was the appeal of the board. Now, say division bench was of the view, we mentioned the matter, division bench was of the view, we are functions of the matter, you have to take steps according to law. Then we have taken out an application, because the single judge's view is, my lord, we have to approach the division bench. Then this order was passed, my lord, 110.
Then you
that the committee in respect of 3 persons of pedagogy.
Sanctus officio observation, where is that?
Well, that's that's
not there.
Take an application.
So you made an application.
Then in disposed of appeal, this order was passed.
Very good.
Now your lordships, this report is ready. What I'm submitting before your lordships, we can submit the report before your lordships. Kindly take up those writ petitions.
Go to the
because both of us mentioned the matter before the learned single judge. Single judge didn't have the time to take up the matter. To cut short the matter, so your lordships can take up and dispose of.
We have no, we also do not have it.
No, let the report be published.
Lord, I tell your lordships.
Milord, may I humbly, Milord, make one submission? Let the reports be circulated. We'll go back.
Report we want to place before the court first, not circulate between the parties.
No, there is.
We have to then your lordships take up the writ petition. That's unfair.
No, Mr. Sannali, you have to go to the trial court.
No, I can. Then your lordships, these applications is not.
Then this application he has prayed for rather compliance of the order and to file the report.
So let us
we will take it on record and we will dispose of the application in the light of the.
Or lordships give us the liberty to mention immediately.
Let the report come. Let the report come.
Take up the matter.
To that, do you have any problem, Mr.?
No, absolutely not.
Let the report be placed, then your lordship will give us liberty to mention, so that there no further time is wasted on that.
Is it ready, Mr.?
Report is ready.
You have it?
No, right now, do not. No, my lord, all that, my lord, if we submit before here.
There will be only one report pertaining to do the.
My lord, there are 2 reports will be, my lord, because I feel one
One is of English and the other is of mathematics.
But
there are 2 separate committees for these 2 subjects.
আলাদা 2022 আলাদা দুটো
If it is ready, Mr. Sannal, you tell us when you.
I'm not on that I'm not place it before losses. All that I'm submitting, you also take up the main matter on the basis of the report. Let us dispose it of your losses.
So it will be.
I tell your losses, I file the report, but if your losses ask me to circulate the further litigation, so let it be considered for by the learned single judge first.
We won't say anything. We will only take that on record in terms of the division bench judge. Our coordinate bench said that you prepared the report. We will record you have filed the report before us, and we will dispose of the application with liberty to the parties.
Absolutely.
So can we take that on record today itself? And what is the other application?
Similar. All similar.
We are all, if I file the report before losses, that has to be again transferred to the learned single judge.
Naturally.
That can be done.
You give it in a cover, it will be placed there.
So, my lord, I wanted that, my lord, kindly request the learned single judge to take up. We go and mention and give the report to the learned single.
No, you give the report. It's been 14 weeks.
As the division bench, coordinate bench has said that if
Yes.
the formality be completed, you give it before us.
No, my lord, your lordships, my lord, if I'm not wrong, kindly have a look at this. Your lordship, page 98. The division bench observation. No, modify হয়নি, sir. No modified, only committee modified. Ultimate direction not modified. Last paragraph. Just because one filed an application that has to be accepted, my lord, that's not the point.
But your application has also been disposed of, Mr. Bhattacharya.
No, these are subsequent applications.
Kindly page 112, you had
Earlier application. Earlier
That is his application.
That's our application.
That is his application.
So after that order, you have filed this application.
Yes.
So what is your prayer in
I
this?
feel that the report of the expert committee, which was thought to be constituted on the advice of the other expert committee, be placed before the court. By public. And let it be published. That's the only prayer.
Page 75.
Once we get to know the report, well, we can pursue the subsequent steps, whether we are entitled to participate.
This prayer, according to me, my lord, goes counter to page 98. Because the division bench in the parent order says
Right,
goes before.
circulation we will not direct. You file the report, let it be on record.
Lord, may I
Let
just-
both of them go to the trial judge and make prayer that let us see that report and we come back and hear fine.
Lord, may I also insist on circulation? I'll tell your lordship the reason.
So circulation, Mr. we cannot direct.
Lord,
Suppose
may I
that
just say this?
that will again, we have to make it again returnable.
No.
Come
Lord,
and say
may
that-
I indicate, Lord, what
Make
is,
that prayer before
Lord,
decision.
may I just take 2 minutes? I have a separate application. I have separate prayers. I'll just take 2 minutes of your lordship's time. Number one, this is regarding, my lord, the TATE 2022 examinations. Certain persons have come forward and said the questions were wrong. My lord, series of orders passed, your lordships have seen. We were able to convince the court, and my lord, expert opinion was sought. Now today, after all these orders are passed, 14 weeks have gone by, report is not here. They have now published a notification saying that we will be inviting applications for Milord jobs. That notification has come on the 25th of September, which is the closing date, Milord, of court. Now, please see the notification. Now, if the report is circulated, all the writ petitioners, Milord, they know what answers they have given in the examinations. So they will know, Milord, whether their fate, Milord, is affected or not. Whether they'll be, Milord, able to get a job or not. Milord, in any case, I have to get the report. I'm the writ petitioner. I will get the report before I make submissions in the final hearing of the writ petition. Milord, there is absolutely no reason why, Milord,
And
my
Mr.
learned friend will.
Bhattacharya is also for some of
For
the-
some other writ petitioners, Milord, I have also made a separate prayer in another application. I have said that if these people,
Mr. Sannal, you give us the report.
Lord, may I make, because I now opposing the submissions of Mr.
No, you give a copy to the concerned advocate.
Lord, may I, that's my
Yes.
I'm telling you. This is an appeal disposed of.
Mr. Sannal, why you are going into technicalities?
Well, all these judgments
the
then too
board
much
is for the
technicalities.
students'
1987 judgment too much technicalities then, my lord.
We
That
are
is an-
simply
you
on
lost-
the issue, Mr. Sannal.
Well, that's why I'm telling you, Lordship, the division bench was opined that please place the report the learned single judge and decide the matter.
Very good. We are not interfering with that. We are only on the basis of the observation of the coordinate bench, we are taking it on record. We are disposing of the applications with copy to the learned
advocates on record,
that's
so that
my
we can
point.
go
We
back
will
and
not,
argue the
want to
matter.
give them.
without prejudice, Mr. Sannal.
My lord, probably I cannot make my submissions clear.
So, you don't want the reports to be circulated?
Before the learned single judge. Let them go there.
What difference?
That's your lordship. That's your lordship. Page 98 goes again.
That will not alter anything.
That's my lord. Then my lord.
Come with the report. When are you coming with the report?
Lord, if suppose your lordships, after having the report, if the single judge is of the opinion that the report should not be circulated, is satisfied, then what would happen?
How can that be?
My lord, that's the I'm losing, my lord, a forum. So let's your lordships get it before the learned single judge. That's the point, your lordships. There was one after another litigation because this was done.
Lakhs of candidates.
No, but these reports are meant for.
My lord, even at their request, they are nominated
We are
university
not-
appointed.
Mr. Sannal, we are not asking you to give thousands of copies. We
No,
will
no,
say
thousands of
one
copies.
copy to the concerned advocate and to the other. That
That's
does not
all,
mean,
Milord.
that does not mean
My lord, I cannot give the report
because
to them because the names of the experts will be disclosed. That's the Supreme Court says should not be.
Let them like that.
Why this? Let it be decided by the learned single. Or your lordship, take it up, your lordship first.
Milord, what is,
That's the judgment of the Supreme Court.
Milord, how is this submission made? Court has
That's
appointed
I'm saying,
vice
let's
chancellors to
dispose of
nominate
appeal.
a
Your lordship can submit.
short the matter, Mr.
Yes.
Sudhir. They will file the report, we will place it here and we give you liberty to go to the signal.
and take a copy, Milord. Take a certified copy.
So that you can make all
Yes,
necessary prayers.
absolutely, Milord. Absolutely.
But is it with you, Mr. Sannal? Can we dispose it of today?
Yes, but
report টা কোথায়?
report now. Tomorrow, report I'm
We'll come
So
back
you
tomorrow.
take it.
Yes, tomorrow.
No, no, tell us when.
ছুটি চলছে তো অফিস ও all offices closed I'm told ছট পুজো করবেন জগদ্ধাত্রী পুজোর পর খুলেছেন
Report was asked to be filed on 11th July and you're saying.
Malad, if report ready, Leonard Singh judge refused to take up to whom we will report submit.
Achha, where is it? You don't have the copy.
Kindly consider this. They also mentioned twice, thrice.
Original copy, Malad, with the seal, Kala seal, Malad, it was handed over to me. But Malad, because of this ensuing vacation, Malad, I handed over to the board because I didn't keep
All right, you comfort those report, put it in an envelope. We will.
It was already in envelope.
Already sealed.
Place tomorrow.
Day after tomorrow to be mentioned.
Tomorrow office bondo.
Malad, kindly, Malad, take Thursday.
But Thursday chuti.
Tomorrow.
Thursday is also
What is happening?
Wednesday morning, Malad, I will
Shocking
take
state of affairs.
at best, Malad. Today, Malad, I will communicate. Wednesday morning, as soon as the office
You
will
ask
open,
me.
Malad, I will be, Malad. given.
All right, 31st to be mentioned. 31st to be mentioned, it will be the first matter you given. Yes, next.
না না এটা কোনটা এটা ডিসপোজ অফ ঠিক আছে সেদিন
Yes, next.
Malad, at least pass one line order, Malad, to produce the report before your loss.
সেদিনকে রেকর্ড করবো।
No, no, to bring that record before bring that report and place before your loss.
আমার কোথায় হচ্ছে? Then you call
No,
them.
no,
এই তো আছে। আবার ঝামেলা।
করি না কেন তো ও চাইবে কি করে রিপোর্ট গুলো তো চাইতে হবে কি বলবো
এখন সব তোমার
Can 30 Amlan.
Can 30 and 31 are the two applications?
Yes, 29, 30, 31. There are 3 applications. Same.
29 is ours.
আর কি সেটা বলো 29, 30, 31. Same.
Read for expert committee report.
Mr. Sannal,
appear on behalf of the writ petitioner appellant.
For the state.
And for
Out
the
of
board-
time.
Yes,
Out
ma'am.
of time.
96 days delay.
How
Can
many
one?
days?
96 days.
67 days delay.
The calculation that has been made, that is 96 days. Madam, paragraph 7 at page 5, I have tried to explain, madam.
What is the main matter?
No, main matter, my lord, the petition appellant before your lordship. Well, before that, would your lordship be kind enough to permit me to file a supplementary affidavit? My lord, because certain documents at the time of filing
What? To what?
to the application can do.
Given copy to me.
Yes, my lord, I have given copy.
What is the matter about?
My lord, would your lordship.
Organizing staff, initially there is a section to organize, to regularize, and subsequently, direction was given to consider, to challenging the order of consideration, they have preferred this.
No, that is not the simplicity, so my lord.
Matter went up to Supreme Court.
This matter.
Initial, this matter went up to Supreme Court. In the Supreme Court, there is a direction to consider afresh. Both considered their case afresh, challenging this order. They filed the writ application. This writ application was disposed of, directing to consider again. Challenging that order, this application.
Place your case.
Yes, ma'am. The Honorable Apex Code had been, if your lordship kindly turns to page 73 of my stay application, can do.
There is no scope for any entry order. Only page 70.
73.
We are allowing section 5, taking the supplementary affidavit on record.
My lord.
Copy,
Yes,
example,
ma'am.
we are keeping a date.
Finally, if your lordship won't come to into another point number 21. There is a simply direction upon the board to consider
the representative.
Challenging this order, appeal has been, I don't know if my learned friend is appearing for the board, whether a fresh decision has been taken by the board or not.
Decision taken?
No, Your Lordship. Your Lordship, Mrs. Bhattacharya is appearing in this matter. She has not come to court. Kindly make it not today. And we have not received the copy of the supplementary affidavit.
Point number 21 of the improved order.
How you are aggrieved by this?
Why, my lord? The Honorable Apex Court had been pleased to pass a liberty to us to make an application as per the prevailing law. In my understanding, the prevailing law at the time the first application was made, the learned single judge has been pleased to find that it should be reckoned at the prevailing time, 1997, my contention, it should be considered before the amendment of the school service coming into effect of the School Service Commission Act, 1997, and 2007 bylaws. This is the only point that is to be decided by your lordship. Whether the law prevailing at the present moment.
So why then you ought to have obtained the clarification from Supreme Court.
No, if your lordship kindly.
Supreme Court order.
Kindly page 73.
So we are taking, you take instruction and come back to us.
Can 1 of 2024.
Milord, I am for that.
Section 5 there.
Yes.
How many days?
122 days.
You're for the state. Any private service complete?
The school is there.
School you have completed?
Yes,
sir?
yes.
Where is your
Milord,
evidence?
today I have not with me. Milord, I have served it. Cool. Cool. Also in the trial court, cool did not appear, Milord.
Maybe, but
I have served, Milord.
show us the order. What is the order? Which order you are challenging?
I am challenging order, Milord.
23rd April.
Yes.
Now, what happened after the order of the DI?
Order of the DI was challenged.
Did not take steps from 2008 till 2022.
No,
Matter
no,
was
no.
kept pending.
Matter was kept pending. Actually, I was subsequently engaged.
Maybe you were subsequently, but
Subsequently
then
engaged.
how
But
can we help you now? Court has upheld the order of the DI.
yes,
Because DI was of the opinion that the rule specified in the prior permission ought to have been followed. That has not been admittedly followed. In
no,
that case,
no, my lord, that is not the case about. Actually, when the
this matter has become infructuous, Mr. Roy.
my lord, not infructuous.
So you show us that it has not been referred to the School Service Commission?
No, my lord, still, this particular matter, my lord.
May be working.
So the post is still lying vacant. I am not working. I am not working there. I am not working there. I have affirmed a letter of the school. The school says that post is lying
At
vacant.
this stage, how can we, just
Facts
because a
remain,
new advocate has come, we have to hear?
My lord, post is still lying vacant. That is,
Maybe, but you were not interested in the.
No, I was interested. I tried, my lord.
How? 2008, you filed the writ petition?
That's true, my lord.
If it is true that it has to be construed that you were not interested.
No, my lord, I proceeded with the matter.
You never proceeded.
I
You filed
proceeded.
and slept.
The my lord, single bench passed several direction. There was direction for filing affidavit by the school, by the government authorities. They did not use an affidavit.
Mr. Raj, that is not an excuse.
No, my lord.
Today, the entire scenario goes. Today also, they do not have the jurisdiction to conduct the selection process afresh.
No, my lord. If I can show from my record of the case that at the instance of the DI.
Yes, what do you say? Post filled up.
No, post
Has the post been referred to the commission?
That I cannot say, Malata. Perhaps it was referred, Malata, because no school is not appearing from the very beginning.
Mr. Badi appeared.
Yes, I appeared for the state, Malata.
Oh,
school is not appearing from the very beginning.
I have
Mr. Badi, you take that instruction after 2008 because the Control of Expenditure Act was 2005. Anyway, you take the instruction. If it was forwarded, then the matter
nothing will remain to do.
Otherwise, we will deal with this point and dispose of. Have you got the letter to board?
Yes,
So we will condone the delay. We will hear you on merit.
Yes.
And then we will condone. There no separate. You complete service upon the school and come.
School I have served, my lord. I have served. I will
Is
get
that so that service?
Lord, in fact, my lord, my entire brief was misplaced. I have taken a copy from him. My lord can take it. I have served.
So you send a further notice.
I will send.
If you have sent,
I will send further notice.
Further notice, we keep it on next 11th. আচ্ছা লিখে নাও হার্ড মিস্টার রয়্যাল অ্যান্ড অ্যাডভোকেট অ্যাপিয়ারিং ফর দি অ্যাপেলেন্ট
Lord, I appear for the appellant. Pursuant to your lordship direction, Lord, I have served the managing committee as well as managing committee has been served, my lord. School authorities have been.
Yes, ma'am. I am for this managing committee and
You are for this.
administration managing committee.
You have got all instructions?
Yes, ma'am.
What documents you are showing? You are relying upon any document?
Yes, my lord, I am relying upon only one document, that is the attendance register of the teachers, my lord. That in spite of my resistance, still the petitioner is signing in the attendance register on regular basis, my lord. At school, he is coming, he is creating some chaos, he is signing at attendance register on regular basis. I am the lady headmistress, my lord. I am trying my level best. I have told him on several occasions, please do not do this.
That is happening since when?
He was ousted, his petition was dismissed on 29th April 2025. Earlier also, when the respondent number 2 asked him not to sign.
Just allow us to go through the order.
Even in this.
You have paid remuneration till when?
31st December 2021. Honorarium was paid.
November.
No, 31st December 2021.
That's
ঠিক আছে তাহলে ডোমা বলবো আমার কাছে যেটা রেকর্ড আছে as per record 31st December 2021.
Have you read the earlier order?
Your lordship's order? Yes, my lord.
You have read it?
Yes, my lord.
You are appearing for whom?
I am for respondent number 4 and 5, headmistress and the secretary.
You are for the DMO.
State as well as director and Duma.
Is Doma. So you have filed the report.
Filed the report. The last order. I have prepared the report.
You have prepared a report.
I have given a copy.
Lord, I have filed the exception on the last date.
Does not file the exception.
আমাকে দেননি তো
It does not file the
তারিখটা বলুন দুখানা তো রিপোর্ট
আমার কাছে আছে
একটা হচ্ছে
এটা দুই এটা তিন এটা দুই
Respondent number 5.
আগেরটা
হ্যাঁ এটা কোথায়
17th September 4th August বলছি রিপোর্ট ফাইল করেছি বা 26 অগস্ট বলছি last order you lordship directed
No. When have you filed that report, Mr. Pursuant to our order of 26th August?
Yes.
When did you file the report?
17th September.
Just today, which you have given today? Acha, acha, acha.
Last occasion I wanted to submit the lordship.
আচ্ছা আচ্ছা ঠিক আছে now we have issued certain directions upon you.
Yes, my lord.
So we are giving, you have been given all copies.
Yes, my lord.
So we have directed you to produce all the approval memoranda pertaining to the approval of the said MSK and the approval of the appellant, including the attendance register. You have asked you to produce all the approval memoranda. You have produced. Is that with you?
Approval, হ্যাঁ, দাঁড়ান। করেছিলাম তো। না, my lord, one thing is this, my lord. Approval is up to 31st December 2025 right now. It has been extended, but a copy of it is not lying with me. Though I am submitting before your lordship that it has already been extended, and every occasion it is extending for 2 years, gap of interval of 2 years.
No, we have asked you, kindly show him the order, Mr.
26th August order.
Please read paragraph
5
internal.
has not appeared before this court in spite of
Respondent 5 has not appeared. Rejected all approval memoranda pertaining to the approval of the MSK, which you are saying till December 2020.
Is with lying with me, my lord. Attendance register is the photocopy of
Not
it.
the attendance is the approval memoranda by which that you are saying that it has been approved till
31st December 2025.
So where is that memoranda?
Then, my lord, kindly give me 7 days of time. Kindly fix it on 31st of October.
But you then file an affidavit.
Achha.
You call your client and let him file an affidavit enclosing all the documents.
Yes, my lord, I will do so. Kindly give me 4 days of time. I will. In the meantime, I will arrange.
We have said you will prove approval memoranda as well as the attendance register of the Shiksha Samprocharok.
Yes, my lord, it's lying with me. It's lying with me. The photocopy of it.
Where is the original?
Original is at school, my lord, because the headmistress initially, when the matter was running in the list in the month of September, last week of September, my lord, just prior to the vacation, puja vacation, my lord, she used to come with that attendance register on regular basis. But that whole register is this one. If she carried it with me with her on every occasion, then others will also.
Very good. Then you do one thing. We are recording your presence. You will get a copy of the report which has been filed,
yes,
which has been newly filed.
Yes.
We will ask him to read. You file a report in the form of an affidavit answering the queries as indicated by the court in its order dated
26th August. Yes, my lord, I will do it.
Let him come and file an affidavit, and therein you say everything. Approval till which month, whether he has worked or not, and the extract of the attendance register you include with that.
Okay, I will do it.
Make that come with that with a advance copy to both him and him so that we can dispose of the.
Yes, ma'am.
So you tell us how long will you how much time will you take to do this?
Kindly fix it on 7th November. 10 days of time for me.
Very good, Ashok. পান ওটা কি লিখলাম একটু ফোরটা কি
for the headmaster. For the state.
What is the matter about Mr.
It's a compassionate appointment.
Compassionate about 2009?
Compassionate appointment died in 1997, applied after 10 years.
এই একটু ফাইলটা দাও তো একটু ফাইলটা দিতে হবে
Initially, there is an order to consider the representation. It was considered and rejected.
Paper book has been filed.
Since there is, my lord, since there is a resolution, madam. Since there is a resolution.
ঠিক আছে ও আচ্ছা তাহলে ডেকে দাও or not to
Sixteen Lordship of
16, I am for the appellant.
Come next day you have taken resolution.
Tomorrow, not today. We are not claiming that we are having that special B.Ed. Not we are claiming that we should have been treated as trained candidate instead of not general millet.
So that issue is pending before Supreme Court.
No.
That is not very good now.